heavy question. Uh, Hello, dear learners. Here is Professor Muhammad Wasim Ali to take your questions. At the outset, I think first and foremost question is regarding divorce. And the question, specific question is, if wife willing to divorce with her husband, by means of khula, so wife returned our amount property to her husband or not. Am I audible? Hello, hello. Yeah, audible. Okay. So the answer of the first question is that according to the Muslim law, if wife is interested to seek the dissolution of her marriage by means of khula from her husband, then if the demand proceed from the side of the wife for the dissolution of her marriage from the husband without any valid reason, and even maybe the valid reason, then in that way, simply if the request is from the side of the wife for the dissolution of the marriage, then the wife will have to surrender the entire amount of the dower agreed upon at the time of the marriage. Therefore, khula basically is a dissolution of marriage at the instance of the wife in lieu of the amount of the dower received or paid to her by her husband either before the marriage, at the time of the marriage, or subsequent to the marriage. Therefore, according to the Indian law, according to the law on khula, a wife is supposed to surrender the amount of dower received from her husband in lieu of her demand for khula. So she will have to surrender the uh, amount of the khula, amount of the dower to her husband, and in lieu of the amount of the dower, the husband will release the wife from the bond of the marriage, and this process of divorce is known as khula, the wife from her husband, which is normally here I would like to find that uh, 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 there are some decisions from the country other than India, from some Muslim countries, and there is a difference of the opinion on this point. Whereas the settled principle of law in India is that in case the wife is seeking the dissolution of her marriage by means of khula, she to surrender the amount of the dower or equivalent amount of the dower. But in Muslim countries, there has been a split of the opinion on this point. And one of the opinion is that where husband has compelled, induced by his conduct or otherwise to seek the dissolution of marriage from the husband, meaning thereby that wife is not at fault. It is the fault of the husband, it is the misconduct of the husband which has compelled the wife in the given circumstance to request for the khula. Then in that very case, one opinion is that wife is not bound to surrender the amount of the dower in lieu of khula, because it is the husband, it is the demeanor of the husband, it is the inducement on the part of the husband which has forced in the given circumstance to the wife to place the demand of the khula. Otherwise, she would not have. if this is the situation, then there is a opinion that in this situation the wife will not be bound and the court will not be bound to order surrender of the amount of the dower in lieu of the khula. Rather, the court can directly order for the dissolution of the marriage even if the husband is not interested. But where the situation is different, and the situation is that if it is the conduct of the wife or wife herself for whatever reasons, wife herself for whatever reasons is not interested to continue in marriage with the husband, and husband is not prima facie on fault, simply the wife does not like to continue in the marriage and she is seeking the dissolution of her marriage means of the khula, then in every case in this situation, wife shall have to surrender the amount of the khula in lieu of the amount of the dower in lieu of her khula. So these are the two different situations. One where wife is at maybe on the face of record maybe at fault, and because of her own fault she is seeking the dissolution of the marriage, she will have to compensate the husband by surrendering the amount of the dower. Where there is no fault of the wife, but it is the misconduct of the husband, it is the cruelty of the husband, it is not proper conduct of the husband that has occasioned the demand of the khula, then in that very case, wife is not bound to seek, is not bound to surrender the amount of the dower. And in case the husband insists on this, the court can pass a decision ignoring the demand of the husband or in demand of the demand for the surrender of the amount of the dower. So these are the two cases, situation. But the settled principle in India is that in case the wife is moving application seeking the dissolution of her marriage from the husband by means of the khula, and husband agrees, then wife will have to surrender the amount of dower received or property received in lieu of dower, or whatever amount of the dower was paid, that amount of the dower will have to be returned by the wife, the husband. Right? Clear? Or now the second question is, in case of the preemption, if any person without telling the proper info, yes. In case the right of the preemption basically is the situational right of the neighbor. Therefore, if there are two properties adjacent to each other in the name of the different owners, or there are co-owners of two adjacent properties, say for example there is a property A and property B, contiguous properties. A is owner of one property A and B is the owner of the property B. X is the owner of property A and Y is owner of the property B, and both the properties are adjacent to each, contiguous to each other. Suppose one of the co-owner X is wishing to dispose of his property A by means of sale. Law of preemption requires that first of all, immediate neighbor or co-owner of the property, other co-owner of the property must be immediately informed of the intention that property A is going to be sold or is being proposed to be sold. Then it is the duty of the X, that is the person who is the owner of the property. He is under the legal obligation, he is under the ethical obligation that first and foremost he should give the information of his intention to his immediate neighbor, who in the given case or example may be Y, who happens to be the owner of the property B, is immediately adjacent property. And in case X has sold his property A, without passing on information of his intention to the owner of the property B, that is Y in the given example, and therefore, and sale deed is finally executed. So as soon as the final sale deed of the property A is executed by X in the name of the Z, say for example, that is the third person, as soon as the sale deed executed, the execution, final execution of the sale deed by X of the property A without any information to the owner of the property B, who in the given example may be Y, then Y will have the right of the preemption. This non-information by X to Y regarding his intention will give rise to the right of the preemption to the owner of the property B, who in the given example is Y. So, non-information regarding the intention to sell on execution of the sale deed to somebody else gives rise to the right of the preemption. But remember that only in the case of the sale, if the property is intended to be transferred by any other means, for example, by means of the gift, by means of the wasiyat, by means of the waqf, then in that very situation, if somebody is making the charity of that very of his property to somebody else, to any immediate to any stranger, then that will not give rise to the right of the preemption. In case information regarding the sale, prior information regarding the sale is withheld, not given, and property is transferred by means of the sale. So as soon as the final sale deed is executed by one owner, ignoring the right of the other, in the name of any third person, any stranger, then the execution of sale deed will immediately give rise to the right of the preemption to the owner, to the co-owner, and he will have the right to step into the shoe of the vendee, who may be the C in the given case, who may be any stranger in the given case, or maybe any other person. But remember that only the transfer by sale will give rise to the right of the preemption. If the property is being transferred by any other means, by any other mode, maybe the gift, maybe the wasiyat, maybe the waqf, that will not give rise to the right of the preemption. And one thing more, that after getting the information that property in question already been sold, immediately he should take the step for claiming the right of the preemption. If after getting the information, he sits idle, does not take any step, keeps silence, that will forfeit his right of the preemption. This is also crystal clear from the ruling of the court in Govind Dayal versus Inayatullah, Mohani Mohan Saha, and Bishan Singh Khajan Singh cases. There are so many cases on the point you can go through. That right of the preemption is very weak right, it is a very feeble right, and this right should be claimed immediately after getting the information that a particular property in question has already been sold without any information, and he has not taken any step, then he will not have his right of preemption will be forfeited. As soon as the information regarding the sale of the property in question is received by the preemptor, immediately he should make the first demand. Then he should make the second demand, and on third demand he can file a suit for getting the property back from the vendee by stepping into his shoe, by paying the sale amount to the vendee. He will be entitled to be substituted in place of the vendee. This is the right of the preemption. Okay. Bishan Singh Khajan Singh case is leading case on this point. Govind Dayal versus Inayatullah, Mohani Mohan Saha versus Sheikh Qudratullah. These are the well-known cases wherein the or right of the preemption has been discussed. Various aspect, various dimension of the right of the preemption has been discussed by the court. For clarity, you can consult the book or case law, rather both. So this is the second question which was raised by Mr. Bushwaha Satyendra, advocate. Okay. Any more question from anyone on any topic? Because I think this is the last session with the stakeholders. So you can ask any question, maybe from marriage, divorce, maintenance, guardianship, whatever topic I have already uh,
Yes, Mr.
discussed.
Can you ask the question, please?
Yes. Any more question?
Sir, I have a question.
Yes, sir, welcome.
Sir, on 25th of this month, we have an examination for Muslim law. So, in that examination, are we expecting only objective type of questions or subjective also?
To the best of my information, objective type of the question will be invited in the ensuing examination. So be ready for objective type questions.
Okay, sir. So, will there be 100 questions or more than 100 questions, sir?
Uh, it will be mentioned. We have already mentioned. I think what will be the number of the question, but what is sent by the SWAYAM will be sent. Will inform. Dear SWAYAM platform itself will inform regarding the number of the question, but probably it will be 100. I think 100 or 150 it may be, but not sure right now. It will be 100 or 150, but be ready for 150. That is the maximum limit. Okay.
Sure.
Okay. Any more question from anyone? So now I am concluding the session. By wishing success in the ensuing examination, and I hope you would have enjoyed the all the sessions which were held previously and subsequently in the form of the question and answer. And still, I think that even before the examination, if you are facing any sort of the problem regarding any topic in the form of the question, or you need some explanation on any point of Muslim law, you are welcome. Even on telephone, you can contact me, and I will be available, and I will try to help you in all possible way. Ladies and gentlemen, even yesterday, I informed that Muslim law is a very dynamic field of law. And almost continuous development is taking place in the field of law. Maybe the institution of marriage, because now the society is moving away from the traditional form of the marriages, and they are opting to some new model of the marriages, maybe live-in relation, same gender marriage, same sex marriages, and some more dilution are taking place even in field of a marriage. So and you might be well aware that recently in recent past in superior case this same-sex marriage was before the Supreme Court, and petitioner was asserting before the has asserted before the Supreme Court that same-sex persons should also be allowed to solemnize the marriage the way opposite gender are allowed to solemnize the marriage, form the union, and at the same time as opposite gender persons are given the status of marriage after forming the union, in the same way, same gender or same sex people should also be allowed to form the union, and they should also be allowed the status of the marriage. After long debate and discussion before the Supreme Court, uh, matter has been finally settled, and now the Supreme Court has come out with the decision on the basis of the argument made out by the government through the Solicitor General Tushar Mehta, that same-sex union will not be allowed to have the status of marriage. They are allowed to live. They are free to live with each other. They are allowed to live in the union, in the form of the union. It is their personal matter. It is their personal choice. Two persons are free to lead their life in their own way. But law is not going to confer any status on the two persons of the same gender, on the two persons of the same sex, even if they have been living just like a couple, just like a partner. They will not be allowed to have the legal status of the couple, that is of the husband or as the wife, as the case may be. This has been finally settled, and in this way the Supreme Court has managed to maintain to greater extent sanctity and status of a traditional marriages. Values of the society has been maintained to a greater extent. So this is one of the development that has taken place, but still the parties are allowed to lead a live-in relationship, meaning thereby live-in relationship has already been recognized. They are that will have the status, legal status, but same-sex marriage will not have the legal status. It will not confer any legal status on the parties of the same sex, but on the parties of live-in relation, law confers a legal status provided certain preconditions are fulfilled by the parties to a live-in relation. In the law, what are those conditions that has already been laid down by the Supreme Court? You can go through. So this is the one thing. Then, friends, so far the divorce is concerned. Sir, just complete. So, dear learners, thank you very much for being with us, with me. I hope we will meet again on some occasion. Thank you very much. अभी मैं जा रहा हूँ, ठीक है?
Okay, thank you very much, all of you, as an official TA of this course, and thanking to all of you. Thank you, all of you, and all the best for your upcoming examination. Thank you very much.